in the administration of these proceedings would want the issues relating to the preliminary matters as well as to the merits rolled over and discussed by the parties at their relevant time. It will be for the court at the end to make a decision. So you roll over. We are not going to split these proceedings and hear preliminary issues first and then go into merits, whatever. We want them rolled over and argued at the same time. That we should do. As I have already indicated, you remember your time, Rule 41. Yes.
Lord, before I get into my time, there is an issue which pertains to the record, which I just want to clarify with the court. We have 3 bundles, but the bundles that we have, it is, my Lord, maybe I need to move this side.
You can switch on your mic so that you are on record, and apparently proceedings need to be viewed by everybody. Yes.
Thank you, Lord. Lord, we have received 3 bundles from the registrar. We are aware that there is a 4th bundle. The 4th bundle contains some evidence, key evidence from ZEC. If I may just confirm whether the court has in its possession that 4th bundle, which has in particular annexures.
Yes, there is. The 4th bundle. This one. We have it.
Thank you, my Lord. I understand that bundle might not be paginated. I'm going to make reference to the report by the ZEC expert, which is in that bundle. It may then take us about a minute trying to locate the relevant pages. My Lord, I just thought I should.
No, that's fine.
This
yes.
in advance.
We won't count that part of your time. When are you ready? You are ready now to start.
I am ready.
You are ready.
I just wanted to clarify.
No, that's fine. We are aware of that. You may start.
Thank you, my Lord. Because of the time constraints, I will not dwell much on the pre-election environment, but I need to make these points. Number 1, it is not disputed. In fact, the first respondent places evidence before the court, which shows a skewed media coverage environment. It is not disputed that the voters' roll, which was given to the applicant the day before the elections, is not the roll used during the elections. It is not disputed that the first respondent went about distributing goodies, and he calls it a presidential scheme. It is also not disputed that people were receiving SMSs from the first respondent and his party.
Sorry, Mr. Mpofu, I don't want to interrupt you. What do you mean when you say it is not disputed? Because some of the issues that you are raising have actually been disputed and are an issue. So you may want to rephrase your submissions.
Thank you, my lady. At the end of it, I guess the point that I'm making is that it is fact that goodies were distributed. It is fact that SMSs were sent. They try to come up with an explanation that is their own explanation. I do not wish to dwell on that. I intend to deal with the figures. My entry point has to be the fact that ZEC admits to making at least 5 errors. It says so in its expert report. It says so in the first paragraph. It repeats that in its conclusion. So it thereby accepts the expert criticism that has been placed before the court by the applicant in that regard. The key issue is that attacks the presumption of validity, which must ordinarily go with ZEC processes. Now, the results announced by ZEC have been disowned by ZEC. The results on the ZEC CD have been disowned by ZEC. Before this court, ZEC has placed a 3rd set of results. So the first results are wrong. The second results are wrong. The third result, as I'm going to show, are also wrong. But this is key. Who has verified the second result? Who has verified the third result? And I'll come back to that. So the declaration made by ZEC in terms of section 110 subsection 3 of the Electoral Act is based upon wrong results. That declaration being final, it can only be set aside by this court, and to the extent that ZEC accepts the incorrectness of that declaration, the matter is with respect resolved. The second issue that I intend to deal with there is if ZEC accepts that the first set of results are wrong, it thereby accepts that it had no primary data which backed the results that it announced. If it then accepts that the results on the CD are wrong, it also accepts that it does not have the primary data to back those results. The third set of results that it sets out must be supported by primary data. Now, there is no such data. The concept of a revolving evidentiary baseline comes into focus. Once ZEC has disowned all its results, the ones that it seeks to stand by must be supported by primary data, and there is no primary data placed before the court. So on what basis does ZEC say the third set of results is correct? But I make the point, who verified those third set of results? The law says you must verify results before they are announced. At page 51, Dr. Otumba makes the point that even on his analysis,
That is
page
51 of which volume?
the first volume, my lady. He makes the point that even on ZEC's own declarations, the constituency returns do not tally with the figures announced by ZEC, and he's correct, because ZEC disowns all the results. I also need to make the point that the correction of these results was not voluntary. It is a correction that came as a response to a challenge. Now, can results be corrected after a declaration? The clear answer is a no, because the declaration is final in terms of section 110, particularly if the 5-day threshold has already been breached. Now, I proceed to deal with the concessions by ZEC, and I make reference in this regard to the expert report. If I may just ask the court to locate the expert report. I relate in this regard to paragraph 1.5. Paragraph 1.5 of the ZEC expert report. That's the fourth bundle. That one is not paginated. It is in the fourth bundle. And I hope the registrar is frozen my time.
Yes, so how do we locate it?
It is annexure Z, my lady. It is annexure Z.
Z.
Z. That is correct.
It's on page. It's on page.
Lord, it is not paginated. That should be the last annexure. It's the statistical report placed before the court by ZEC. There is the problem. It should have followed its sequence. Pardon, Lord? Annexure Z.
We are at the page you are referring to.
Thank you, my Lord. If I may just
Yeah,
ask for
next
30 seconds.
All right.
Their lordships are also still
All right.
locating
That's the affidavit by Dr. Mpambire.
That is correct. He attaches a report, and it is that report, my lord, that I'm looking at paragraph 1.5. As we look at the paragraph, if I may just indicate that once we knock off 31,830 votes, the 0.8% by which ZEC says first respondent scaled the statutory threshold disappears. And so the figures that I will deal with in this regard will primarily deal with that issue. I notice Uchena JCC is still trying to locate the page. Can I proceed, my lord? Oh, it's the 0.65% by which they say is scaled, rather because they've revised it 3 times over.
Sorry, what paragraph?
Paragraph 1.5, my lord. The paragraph headed net effect on presidential results. It is page 19 of Annexure Z. Unfortunately, my lord, there are some members of the bench are still trying to locate the. Don't know whether, ladies and lords, everyone has managed to locate the relevant passage so that I fire on.
Yes.
Thank you. Now, in paragraph 1.5, this is what the expert says. He says he has done a recalculation and he sees that 4,491 votes had been taken away from Chamisa. Not only were 4,491 votes taken away from Chamisa, but 4,453 votes were reduced from Mnangagwa. In other words, they'd been added to Mnangagwa. So the effect is that the gap is actually 8,944. The 4,000 and something by which Chamisa had gone down, and the 4,000 and something by which the first respondent had gone up. So a figure of 8,944 is accepted. Secondly, still in the same report, and I draw attention to paragraph 1.6.4, and I'm at page 24. There is a schedule showing the double collation of results. And this is what ZEC says. It accepts that in the Mbire constituency, the first respondent had unlawfully gained 2,293 votes. In the Rushinga constituency, he had unlawfully gained 5,410 votes. That is knocked off again from his tally. It produces a sum of 7,730. Plus 16,000 already, we over the halfway mark. Now let us go to the next issue.
So what page is that?
It is page 24, my lord.
Page 24.
That is correct. So from ZEC's own figures.
What are the figures again? Can we have the figures again?
The first set is 8,944. The second set is 7,730.
Those figures, Mr. Mpo.
First at page 19, paragraph 1.5.
Uh-huh.
the 4,491 and the 4,453. And then secondly, at page 24, when we get to the Mnangagwa column there, there's that variance, 2,293 for Mbire, then 5,410 for Rushinga.
But Mr. Mpofu, it's not, the narration is not sequential. At page 19, we're told after the correction of observed errors. Are these not the errors observed at page 24?
They're not, my lord. They're not.
Yeah,
They-
but then
they-
which are the ones, which are these observed errors? in
The
order
errors
to-
at page 19 deal with the results as they appeared on the CD and how they differ from those that are announced. The errors at page 23 deal with a specific challenge, the double collation of results. Lord, put differently, if you look at the errors at page 19 and the errors at page 23, they do not produce the same mathematical figure. And for that reason, they cannot be the same. They are different. In fact, that is a position made by the applicant, and that is a position which ZEC has not been able to rebut. Now I move to the next. The next is the presidential, the difference between the presidential and the parliamentary tallies. That difference is admitted. It produces 40,717. It leaves this court with one question to answer. Can this difference exist by law? The answer to that is in section 56, subsection 3A of the Electoral Act. The Electoral Act says in harmonized elections, if a voter comes and chooses not to vote in the 3 elections,
Sorry, what section?
56 3A. If a voter comes and chooses not to vote in the 3 elections, ZEC must make an entry. The entry which ZEC makes is in a form called PE 2005/AA. ZEC has not produced those entries for the 40,717 variants. It has not produced those because they do not exist. So that huge gap, so ably typified in Mutare North, has not been explained away. Those are created votes. I move to the ghost polling stations. The ghost polling stations account for 9,592 votes. That is at pages 164 to 165. The key issue which ZEC tries to duck, but it can run, but never hide, is that there is a deposition by Tawanda Ralph Magunje. The deposition by Tawanda Ralph Magunje has not been disputed. He says those 2 identified collations came in and were from polling stations that did not exist. Instead of ZEC placing before the evidence before the court, which shows that those collations are from existent polling stations, it says you have mischaracterized your complaint. You should have said ward and not polling station. But that is not the issue. The issue is that the 9,592 votes came from non-existent polling stations. That has not been disputed. The affidavit of Tawanda Ralph Magunje is at pages 86 to 88. I then move to the question of there being more votes than those registered. The ZEC experts accepts the criticism by Dr. Otumba, the applicant's expert. He, however, tries to say these were mispostings, but those protestations, again, are without any validity. The declared results arise from information, from data, which ZEC now says is wrong. But it is not correct that there were no instances where more votes were cast than the registered voters. And I relate in this regard to Belvedere. Madosi has placed an affidavit before the court. Salai Guana does not dispute that at Belvedere, people came who were not on the voters' roll and were allowed by him to vote, allowed contrary to statute to vote, and they did vote.
What pages?
The Madosi affidavit. Thank you, my lord. I'll just get to the Madosi affidavit in a short little while. Madosi is 82 to 85 of the first volume. Of volume 1. 82 to 85. 82 to 85. I'm just giving that as an example. There is also the Norton example. When 900 people voted, and yet the upper limit was 611. The first respondent says this was a slip of the tongue from the ZEC official who made that announcement. And then there is no affidavit from that ZEC official to say, no, my tongue slipped. I was not truthful when I spoke to the ZBC. So that phenomenon is once again established. And I move now to Mashonaland Central with something different. Mashonaland Central at page 159. I invite the court to consider the report by the ZBC. It does two things. Number one, it mentions figures. Number two, it attributes those figures to a ZEC official. It says by 5:30 p.m., 105,000 people had voted in Mashonaland Central. The final figure that one gets from ZEC is that an hour and 30 minutes later, plus 370,000 people voted, which takes the final tally to 444,000. It was incumbent upon ZEC, once that allegation was made, to place before the court the affidavit of Tim Kandla, disowning these figures, disowning the fact that she spoke to the national broadcaster. ZEC has not done that, and there can be only one conclusion. But it doesn't end there. Mashingo. At 9 o'clock, the 24th respondent issues a statement, and in that statement, she says by 6 o'clock, there had been a 60% voter turnout in Mashingo. The final tally that ZEC gives shows an 84.16% voter turnout in Mashingo. What ZEC is saying, which I urge the court to disregard with the contempt that it merits, is that in Mashingo, 24.16%, there was a 24.16% voter turnout in an hour. ZEC does not explain these figures away. I move to the question of the civil servants. It is asserted in two affidavits, Masaraure and Maopa, that there were 60,000 teachers who were involved in the ZEC processes, and that only 20,000 of those voted. ZEC responds by doing two things. Number one, it places affidavits of people who say, yes, we agreed to forego our right to vote. but then he doesn't place more than 20,000 affidavits before the court. Because it is at least accepted that 20,000 voted. So what ZEC must do is to show that those people who decided to forego their votes were more than 20,000. It doesn't do so. But secondly, the affidavits, particularly of Masarawe, says the day before the election, Kubani Moyo, Commissioner Kubani Moyo, indicated that a court order which had been granted by the High Court was not going to be complied with. Kubani Moyo has not placed an affidavit before the court refuting that. I need to make two quick points. The first is that once the High Court said ZEC had to allow the teachers to vote, ZEC had to do so. ZEC and the teachers could not vary a High Court order. I draw from CFU versus Muriro, which says by no lawful device can parties, even by their agreement, agree to vary a court order. But the second point that I make is one founded upon provisions of Section 92 of the Electoral Act. By statutory command, every employer, the state included, is obliged to ensure that its employees, his employees, her employees vote. So when ZEC comes to court and says we got into an arrangement which took away from the teachers their right to vote and they are fine with that, that is contrary to at least two precepts. Number one, a court order. Number two, a statutory provision. That can have no validity. At the end of the day, there is no bona fide dispute on the fact that some 40,000 teachers did not vote, were supposed to have voted. The next issue that I deal with is the postal voting. But can I just ask for 10 minutes? I would just like to finish dealing with the figures and say something briefly.
How long do you want to take?
10 minutes, my lord.
10 minutes.
10 minutes, my lord.
All right.
Thank you, my lord.
Grant you the time.
There is an affidavit by Squiddan Chirodza. Squiddan Chirodza says there was a mock polling process at Roscamp. ZEC does not dispute that. In terms of the law, I refer the court to section 74, subsection 1, 74, subsection 3, 75, and 76 of the Electoral Act, which makes it clear that postal voting is a private affair. You vote in the comfort of your room, and then you send the postal ballots away. That is not what happened. By ZEC's own admission, it affects some 4,400 votes. Then there is the issue of identical polling results. It is dealt with in paragraphs 103 and 104 of my heads of argument. The relevant pages with the evidence, pages 168 to 173. And this is what comes out. There are at least 16 polling stations with identical results. Identical results for Chamisa, identical results for Mnangagwa, identical spoiled votes. That, with respect, is to take us for granted. But it doesn't end there. When Chamisa gets 1 at a polling station, Mnangagwa is 68. So there would be two examples. When he gets 1, Mnangagwa would have 68. When he gets 12, Mnangagwa would have 48. When Chamisa gets 14, Mnangagwa will get a similar number. All that comes out in pages 168 to 117. It's like a kid was playing with the figures. That, with respect, is not how an election is conducted. Then there's the issue of proximity polling behavior, where you have in one ward, wards that are polling stations that are 2 kilometers apart. You have Chamisa getting more than 40%, 60% at a polling station. And at the next polling station, he has 1%. All that is before the court, and it is dealt with at pages 46 to 48 of the first bundle. And final on the figures, you have places with a plus 95% turnout, 97% turnout, 96% turnout. of voters. And in all those places, Mnangagwa not only wins, but wins big. The cumulative figure is 352,897. That, with respect, cannot be in accordance with the law. Now, when all this happens, there is no proper verification process before results are announced. In fact, ZEC announced results from 9 provinces when it is supposed to be announcing from constituencies. Takes a break and comes back and announces the rest. How does that happen? What kind of verification is that? But I wish to make this point. In terms of the law, a verification of a presidential result is verification of V23s. What comes to the National Command Center are V23s, and it is those that are verified. What ZEC was doing was to purport to conduct a process that happens at ward level, inputting V11s into an Excel. That, with respect, is not a verification process. But ultimately, and I've made this point, I close on it. When one accepts that ZEC has disowned its results, the later results can have no validity unless they've been verified. And it is common cause that they were not. So I turn to the point in limine. ZEC, which has changed results 3 times over, ZEC, which fails to deal with these figures, purports to take a point in limine. That, with respect, cannot be accepted. And the point that it takes in limine is not only arid, but it is altogether desperate and unworthy of the position that it must occupy. The correct factual position is that the application was lodged. Not only was the application lodged, but the sheriff who must save process was given instructions when he still had 8 hours to save process. Legal practitioners have placed before the court affidavits which show that the sheriff was instructed to save. He initially agreed to save, but then turned around and said he had been instructed not to save. And one can see that the person who instructed him thought that service ends at 4:30, and that service, in terms of his own rules, ends at 10 o'clock. And for this kind of process, we submit that service would end at 12 midnight. But the fact of the matter is that applicant cannot comply with what the law requires of him, places everything before an officer of the court who must execute an instruction. That officer refuses to do so, turns around and affords the first respondent, turns around and affords ZEC the opportunity to take not only a false point in limine, but one which, with respect, strikes at the heart of the process that is before the court. Before this court is an application which seeks to vindicate the Constitution. Before this court is an application which feeds into the lifeblood of our democracy. Before this court is an application in which the first respondent must establish that Zimbabweans voted for him before he can get the chance to rule the country for 5 years. But not only that, in terms of the decision in Tsvangirai, once an application has been lodged, and Black's Law Dictionary says to lodge is to file, and to file is to place before the registrar. Once the application has been lodged, the jurisdiction of the court is assumed. The lodging of the application within 7 days triggers the assumption by the court of its jurisdiction. And what jurisdiction is assumed by the court? That question is answered by this court in Tsvangirai versus Mugabe. Court says the lodgement of the petition or application under section 93(1) of the Constitution does not only commence proceedings, it gives the petitioner or applicant the right to be heard by the court in his or her cause. It imposes on the court the reciprocal obligation to hear and determine the petition or application. The matter is sealed. Once the application has been lodged, the court assumes jurisdiction to deal with it on the substance, and that cannot be taken away by a technical objection. Not even applicant's own technical objection. Indeed, in Tsvangirai, the court said even if applicant wants to withdraw the application, he is not in a position to do so. Once the application has been lodged, it becomes a matter between the people of Zimbabwe who deserve to be governed by a person who won the election. It becomes a matter between those people and the court, which must interpret the constitution. It becomes a matter between the court and the constitution, which it must interpret. So there are three parties involved. The people of Zimbabwe, their right to a free and fair election, their right to self-determination, their right to proper constitutional and democratic governance. On the one hand, the court in the middle, and on the other, the constitution, which the court must give life to. I also then make the point that once the first respondent, in chorus with the 23rd respondent, take us from the constitution and to the rules, those rules have to be read together. Those rules say in Rule 3.2, you do not compute weekends. And so the matter is resolved. And there's actually an interesting aspect there. The first respondent, together with the 23rd respondents, on their own argument, filed the notices of opposition out of time. The reason they filed the notice of opposition out of time is that registry was closed during the Heroes' holidays. So they cannot say we couldn't file on time because registry was closed. So hear us. But then at the same time say, although you asked the sheriff to effect service and he refused, you must be non-suited. That with respect is not the kind of attitude to be adopted in these kinds of matters. I then deal with the objection to the notice of motion. The addresses of the respondents who take that point appear in the attached schedule. There is nothing in the rules which says you cannot attach bulky addresses to a schedule. So that point really is neither here nor there. They then turn around and say proof of service was not placed timeously. They rely again on the sheriff, because it is the sheriff who effected service, and the sheriff must have placed that proof before the court. It is a court process. Cannot, with respect, do this. But whilst that forms the backdrop, here is the crux of the matter. In terms of the rule which they rely on, it is for the registrar to deem a matter abandoned. If the registrar does not deem a matter abandoned, that invests an aggrieved party with the right to approach the court and seek a mandamus to have the registrar deem a matter abandoned. The registrar is not deemed the matter abandoned. The point taken in limine is with respect without merit. Finally, they say there is no evidence placed before the court. They allow themselves to be taken by the tide of a bundle which should have been accepted by the registrar, and which, for reasons that we do not understand, the registrar refused to accept. But that really is neither here nor there. There are two pieces of evidence before the court. There is evidence attached to the founding affidavit, and then there is a separate bundle. That separate bundle deals with the electoral environment. It does not decide anything that is before the court. What deals with the substantive issue is evidence which they accept is properly before the court. It is the figures. Now the court will notice one thing. In their heads of argument, the first respondent, the 23rd respondents, Lord, if I may just 1 minute. 1 minute.
Are you sure?
Oh, maybe Lord, let us just make it.
We don't. Are you sure we don't want to keep on saying 1 minute? 1 minute.
Let us just make it 5.
It's up to you.
Let us make it 5, my Lord.
5.
Let us make
All right, we'll give.
So the issue stands to be determined on the basis of the figures. The first respondent says nothing about the numbers. The reason is clear. Numbers do not lie. The 23rd respondent ducks and dives. Numbers do not lie. When we aggregate the figures that I've already related to, we are above the 31,000 threshold. And on that basis, a runoff is unavoidable. I would have wanted to complain about our subpoena, because that subpoena, well, we properly took it to the registrar, and the registrar refused to issue a subpoena, which should not happen. The registrar must issue process. And if that process is challenged, it is challenged in court. But that process would have placed before the court evidence which relates to our other declarations. But for now, the election must be set aside. Now I relate to the test. Lords, if I may just ask that my learned junior, Mr. Ashiti, just relates to the test and to the remedies in the 4 minutes that are left.
It takes the 4 minutes.
It takes the 4 minutes, my lord.
You heard that, Mr. Ashit.
My lord, loud and clear. And my lord, I will not take more than 4 minutes. My lord, the tests that the court considers when invalidating this kind of shambolic processes, my lord, was spelled out by His Lordship, the Chief Justice, in the Tsvangirai judgment. The test, my lord, is not that the result is materially affected. What the court has said is that the test goes to the validity of the process. My lord, I refer you to the heads of arguments that were filed for the applicant. They address those authorities in detail. My lord, the particular finding you made in interpreting Section 93, subsection 3 of the Constitution was that the validity of the election is what is in issue. It is the validity of the entire process, my lord. It is not the validity simply of the result. My lord, there are authorities we have placed that indicate that an election is not an event, it's a process. And my lord, you had reason in the Mawarire judgment that I would recall to indicate, my lord, that once the rule of law as it relates to a declaration of elections is violated, the entire rule of law as regards the entire process becomes flawed. So, my lord, once you find that there is no valid result, you also find, my lord, there is no valid election because of the other reasons my learned friend Mr. Mpofu addressed you on. Consequently, my lord, I will be preaching to the choir if I were to indicate, my lord, that the test is not as narrow as the respondents would like you to believe. In fact, my lord, in the Mawarire matter, you indicated that the rights of the people are constitutionally guaranteed. They have a right to a democratic governance. They have a right to a social contract with the governors. That contract is not a one-day event. It's a contract, my lord, which commences with a declaration of the election dates. Once that is done, everything that follows must follow the letter of the law, must follow the will of the people, must follow the evidence, and must conclusively reach a result, my lord, which is not only in accordance with the law, but most importantly, as argued by my learned senior, Mr. Mpofu, follows the mathematics. Once the maths are gone, my lord, there is no process at all. And you will notice, my lord, the law settles it, that once an admission is made, it is binding until recanted. ZEC made the admission itself. It confirms that the result it announced was flawed. It itself arrogated itself the power to set aside its own electoral processes. By the mere fact of announcing a different result from the one declared, they accept that their process was not valid as at the time they made the declaration. My lord, that settles the matter. Once that is found, my lord, considered as they have done, my lord, we cannot talk anymore of any legality or any test. And then, my lord, you will consider the narrow test, which is in section 177 of the Electoral Act. Even if by the narrow test, the evidence has been led that to meet the narrow test, the 38,000 votes, the 31,000 votes that constitute the margin, my lord, by which the first respondent was declared winner has been set aside. The mathematics don't lie, my lord, the figures don't lie, even to lawyers. My lord, I rest my submissions.
You rest.
Unless if there are specific issues, my lord,
Are you resting your position?
Yes, my lord.
Yes. Once a bell is rung, nobody will listen to you.
I know, my lord.
You're talking to yourself.
I am aware of that, my lord.
You are aware of that,
I practice
yes.
in this court very often, I know it.
All right. So if you want us to listen to you, you follow you ask for permission to get more time, but we have granted the times, and you are now at the end. You are satisfied with what you have said?
Yes, my lord, particularly because Melenet Senior addressed the relief sought that a runoff becomes inescapable. And that is the relief, my lord, that the applicant moves.
Yes, thank you. Just one or two questions.
Yes, my lord.
There is reference to figures not adding up and founding conclusions that the court is asked to accept. Why does the applicant decide to found his case on secondary evidence when there is original and primary evidence?
My lord, with your kind leave, might I defer to Melenet Senior who argued the point?
Sorry?
With your kind leave, my lord, might I defer answer of that question to Melenet Senior who...
No, there's no problem here. Between the two of you, you are free. It's your case.
When did it, my lord?
Thank you. Lord, in answer to that question, there are two main submissions to be made. The first is that there is no need to defer to what has been identified as primary evidence when the figures are admitted, when the figures are an analysis of ZEC's own figures. So if ZEC says Mnangagwa amassed these kinds of votes and we establish that he did not, and ZEC accepts that, we do not go to the V11s. The issue is resolved at that level. In fact, at this stage, the evidentiary onus to place primary data is on ZEC because ZEC has disowned two of its results. It has disowned the results announced on television and pursuant to which a declaration is made. ZEC has disowned the results on the CD, which it gave the parties after the announcement. ZEC has now come up with a figure which was not verified by anyone. It is now up to ZEC to establish the veracity of that figure. So, my lord, the key case for the applicant is not based on extrapolations, as the respondents would have the court believe. The key case of the applicant is based on ZEC's own figures and data which are wrong. That's the first response. The second response is that the primary data cannot be related to by the applicant. In his own words, it is a poison chalice, and let me demonstrate that with reference to some page numbers. Let me start with volume 1, page 186.
Sorry, what page?
Page 186. That's a V11. That V11 is signed by the parties, stamped by ZEC. It is not filled up, it is not populated. That irregularity is stuck. At page 189,
Sorry, can you repeat what you just said, Mr. Mbo?
that V11 is signed, stamped, but not populated. At page 189, that's another V11. It is signed, it is stamped, it is not populated.
But it is not
Populated, there are no figures. Page 192, that's another V11, signed, stamped, not populated.
Are these originals?
Pardon?
Are these the original V11 forms?
These are the V11s. Correct.
Are they copies or originals?
Oh, well, the ones before the court would be copies of the originals. I have the originals. I'm prepared to place them before the court. They're here. Can we place them before the court?
Why I'm seeking this clarification is precisely because of what you are talking about.
Thank you, my lord. I'm actually dealing with that, so I just want to draw attention first to the relevant V11s and make a point.
Yes, I'm interested in knowing why the applicant did not seek to do what the law allows him to do as an applicant, a candidate aggrieved, to place the original documents, the residue, which are the documents which are original, which were signed by the parties, polling agents who would have been there in the presence of observers and were sealed and are in ballot boxes which are still sealed. Why did the applicant not seek to have those documents, those boxes opened up so that an analysis of all these documents inside there would have allayed all these disputes?
Thank you, Lord. That is exactly the issue that I'm answering, because they've raised it, and I want to deal with it in a systematic manner so that it becomes clear to the court that that avenue, though ostensibly available by statute, is not for practical purposes available to the applicant, because there's been a massive cover-up, there's been a massive doctoring of that evidence. So that is what I want to establish.
That would be a fact established by the very process that we're talking about. It's like somebody who makes a declaration but refuses to base it on the substantive, factual conditions.
I'm getting them not for...
We are just worried why that was not done. That's why we are saying there is secondary evidence, and yet, which is in some cases disputed. We know you are now saying the ZEC has admitted many things we don't know. Whether they'll agree, we don't know. But we as a court are saying, why are we being made to discuss matters on secondary evidence that is highly disputed?
Thank you.
When there would have been a process which would have introduced everybody before the case came to court, and a position would have been shown as to why, whether certain statutory obligations which we know of were complied with or not.
Thank you, my Lord. I would like to deal with that issue in a systematic manner. I will not be long on the issue. That's why I'm making reference to these V11s, and I've placed the originals before the court. My Lord, if I may just make reference to all of them and come and deal with that issue. So I'm now at page 192. At page 192, we see a similar phenomenon. And we also see that at page 195. And for my purposes and purposes, also at page 199. Now, why do we have...
Thing, Mr. Mpofu, perhaps you may not be understanding me properly. These are reflections of activities which are, by your submission, contrary to the legal requirements of how the election ought to have been conducted. In other words, they are presented as activities that subvert the law, the legal requirement. But you have documents which were compiled in the presence of everyone who has an interest. And those are the documents that should have been accessed by everyone concerned who has an interest in establishing whether what was done at every polling station complied with the dictates of the law. Do you see what it is?
That is exactly, my Lord,
Yes.
what I want to answer.
Yes.
I'm clear on His Lordship's question.
Yes.
I'm very, very clear, my Lord. That is what I want to answer, and I want to answer it substantively,
Yeah.
and in a manner which eliminates all scrapple, in a manner which answers all doubt. The point that I wish to make is that this is evidence of manipulation by ZEC after the process. Now, with this evidence of manipulation after the process, if you go to what they call the primary data, you're going to see manipulated data. So the applicant cannot ask a court to open residue which has already been manipulated.
Is that admitted?
I want to establish that.
Sorry?
I want to establish that. And maybe let me actually give two responses to that. Number one, my lady, it does not have to be admitted. Once we see this evidence of manipulation, ZEC does not have to admit that it was manipulating data. We rely on the evidence of manipulation. We say to ZEC, explain why you have signed by 11. And what does ZEC say? It says it is an inadvertence. That is their word. The word they use is inadvertence. But now here is the problem. I've placed some V11s before the court. There is not a single affidavit from a presiding officer who was involved at those polling stations admitting to the inadvertence. So once we have this evidence of an attempt to cover up, which ZEC cannot explain away, that with respect is the end of the matter. Secondly, there are two critical affidavits before the court. The first is the affidavit of Mazuzo. It is at pages 118 to 121 of the first volume. Mazuzo explains something which helps the court understand what was happening with these signed but unpopulated V11s. He says after they had conducted the election, after they'd done the counting and the collation, people came with these kinds of V11s and wanted him to sign, unpopulated. So what clearly happened from the papers, and which ZEC will not explain away, is that there was this covering up process, and there was then a population of the V11s in a manner which was meant to be consistent with the result which ZEC had cooked up. So if you go to the residue, you drink from a poisoned well. So the applicant
to drink from that. Surely you can't tell us we shouldn't drink from that poisoned well, if that is how the truth should be established.
Now, my Lord, here is the issue. Once we say for these reasons we do not want to drink from a poisoned well, and we have set out these irregularities, it is for ZEC to then say the well is actually not poisoned, and this is how it is not poisoned.
Making a mistake. There is a difference between the two of you. Whatever positions you take, you are free to take. We respect. There is a position of the court, the Constitutional Court. It must make a decision it must make a decision that is founded on proper evidence, on articulation. We'll take all these things, all the facts into account. But at the end of the day, we still have to ask you this fundamental question.
I hear His Lordship,
Yes.
and my Lord, I'm still answering that question from our perspective.
Yes.
And saying
For example,
why.
if the those residues in the ballot boxes had been opened, one is, would it be accepted that those ballot boxes would have been sealed in the presence of observers, in the presence of polling agents? If those polling agents were not there, why were they not there? Those are the issues that we need to be, would have wanted to hear.
And my Lord, believe me, in my systematic response to that issue, I am dealing with all that. So I'm taking the court step by step and explaining the process from our perspective. But I hear His Lordship. So the next page reference is 91. Page 91, this is an affidavit by Dr. Admaya Virimai Jira. It just supports what I've been talking about. I want to read it from the middle where it says, the presiding officer chased away and the other polling agents, and whilst the votes were being counted, she was called to sign the forms by the presiding officer after the counting of the votes, and she refused. She went back to her homestead. On the 3rd of August 2018, at around 1 a.m., a group of men came to her house. The men had covered their faces with ashes. The group of men blindfolded her and her husband and dragged them out of the house. The group of men assaulted her with logs on. The men took turns to sexually abuse her, and the husband was also sodomized by the group of men. Now, this is evidence which shows that attempt once again at covering up. And once there is this covering up by ZEC, we can't go to their processes. They sodomize people, they rape people because they've refused to participate in the covering up. But it doesn't end there.
Mr. Mpofu, where did Dr. Jira get this from?
From the clients that she attended to. And this is a statutory affidavit, my Lord.
So
He's
basically,
identified names.
He's relating what has been told by somebody else.
He is. That's first-hand hearsay, admissible in terms of Section 24 of the Civil
No, I
Evidence
appreciate
Act.
that. But obviously, the issue that arises is the weight.
Indeed, my Lord. Indeed. And there's actually no proper rebuttal to this. The next issue that I deal with, the EU report, which is before the court, shows that at polling stations, these V11s were not posted on the notice board.
On specific, outside specific polling stations?
Indeed, those are identified. Those are
They've
identified.
been identified.
They've been identified.
Which polling stations?
It is set out in the
Which polling stations? Because we have read these papers. Where did the EU get that? Which polling station is it talking about?
Thank you, my Lord. Let me place before the court the statements that are from pages 1262 to 1267. 1262 to 1267. That would be the third volume.
So, volume 3, is it?
The third volume.
can be 462 in the third volume. Third volume starts with 959.
Yes, I'm relating to the statements which start from page 1262. 1262, that is correct, my lord.
1260 something?
Is it not 962?
Pardon, my lord.
Is it not 962?
962, let me confirm that, my lord. There is that report again, my lord. That is correct. Let's. At page 973, His Lordship, the Chief Justice, talks about a process which would have been done in the presence of the observers. And now this is what the observers say. Page 93, paragraph 3.
So it's
973, pardon me, my lord.
973.
973, paragraph 3, the very last sentence. EU observers reported that the results were not posted.
Yeah, Mr. Mpofu, I don't think we have the same pages. Our 973 is no paragraph
The third
3.
volume, my lady.
Yeah,
Third volume.
yes.
Let me just try to ascertain what has happened. 973.
Yes, no, this is the one.
Right at the top, there is a paragraph 9, and the heading is polling and counting.
Yeah, so you said third paragraph, not that it's numbered 3.
It is not numbered 3, my lady.
It's not numbered.
That is correct.
Very well.
Well, maybe this is the penultimate paragraph.
Part of paragraph 9.
Correct. EU observers reported that the results were not posted at the polling station in 10 out of the 52 polling stations observed. So we go to the primary source, which must...
No, but you are not answering what I asked you. That is something that can be said by anybody. What stations are they talking about? Which one? They visited them. They saw them. Which ones? We would have loved to hear the EU tell us the stations, the polling stations, particularly where they say themselves that the procedures were largely followed.
Lord, here is my response.
Yes.
When it comes to these observer missions, because His Lordship asked a question which required us to go to some primary source which would involve observers as well. Now, when we get to them, we can't take one part of the report and reject the others. His Lordship correctly notes that they have said...
No, but we can't act on generalities. We are a court of law. We act on evidence, on proof of facts. And where is proof by the EU observers mission that there were polling stations where V11 forms completed by, whether completed or not, we're not told,
Lord, we've been looking for...
were not posted outside. In other words, if they are V11 not posted, that's a different thing from saying V11s were not completed. What is it that they are saying? Is it that they were not completed? Or is it they were completed but they were not posted outside?
Lord,
which stations are we talking about?
Let us go back to His Lordship's intervention. The reason I've taken His Lordship to this report is that His Lordship said, let us go to the primary source, because this is what we establish from the primary source. We establish the involvement of the parties and observers. So I have now...
No, don't misquote. We don't know what is in those residue. We don't know. It is precisely because of the ignorance that we have, which should have been allayed by us having access to those real documents. They are really evidence. They are original evidence. They are expected to reveal evidence of compliance with the law at its source. These are people who were in those tents. These are people who were actually seeing people voting, moving from one place to another. The polling agents were there. They should have been there in terms of our law. Section 54, right up to section 65. They require all that.
Thank you, my lord. Let me.
So we want to know, what are those who were present, conditions of perception, of presence, of action, of sealing? How are they being reflected in terms of evidence?
Thank you, my lord. I would like my argument to remain before the court undistorted.
Yes.
And let me take it again at this stage, so that, my lord, I'm not lost by the court. My argument is twofold. Number one, when you look at the figures, let's look at those that have been admitted by ZEC. Let's look at the parliamentary tally. Let us look at the ghost polling stations, for instance. When we establish those figures, as I submit we have, when we show that 40,000 people are said to have voted in the presidential election and not in the primary election, and ZEC does not have returns which show that there were people who simply chose to vote in the presidential election, that is the end.
So those returns would not have been put into the ballot box?
No, they will not be put into
No.
the ballot box. They will not be put into the ballot box. It's separate material.
There is, I think, common cause knowledge that there was no voting for parliamentary elections in some constituencies. What would be the effect of that?
There is with respect, there is actually no such evidence from our reading of the papers. All the parliament, there was voting in all the 210 constituencies. There was voting in all the 210 constituencies. The point, the point, my lord, that I'm making is that once there is a disconnect, once there is a dissonance between the parliamentary tally and the presidential tally, the obligation is on ZEC to establish that there are people who voted in the presidential and not the parliamentary, and they have certain returns which they are required by law to complete. And if they had those returns, they would have placed them before the court.
Advocate Mpofu, just to go back to the initial question, as presented, as formulated by the Chief Justice. Let's put it differently. You say that the V11 forms were manipulated or forged in certain instances.
That is correct. That is correct. That's for purposes of my second response.
Yes, no. Now, surely the best way to confirm or dispute that would be to look at the actual ballot boxes in those particular stations where those V11 forms are disputed, would it not? In other words, what is contained in the residue in the ballot boxes would establish that those forms were manipulated or forged. I think that's the question.
Not really, my lord. This is really where this is where the issue is. Once we have those irregular V11s that I've been drawing the court's attention to.
Yes, but how many are they in relation to the total V11 forms that may have been filled in percentage terms, if you have the figure?
Well, I haven't done that math, but for the purposes of my answer to this question, I'm required to explain why, because we are not obliged to do a recount. I'm required to explain why the applicant did not consider it prudent to follow the statutory recount or residue opening route. And the substance of my answer is that with all these irregularities that is established, he cannot follow a process which has clearly been a subject of a cover-up.
Yes,
So-
I think
so-
why
so what he
perhaps you
does-
could, if you could try and understand me, you have referred us to a number of copies and even handed us the originals, but I'm asking in terms of numbers, because you are the ones who are saying numbers
Don't lie.
do not lie.
They don't.
So what is the percentage of these V11 forms that you have drawn our attention to in relation to all the polling stations that were in place
That is
and at which these forms would have been or should have been
In-
filled
in-
in and posted outside?
in 7 days, my lady, we cannot have all that evidence. What we require to establish in 7 days is systematic rigging. So once we have V11s from across the country showing an irregularity which is not explained away, the systematic nature of the cover-up is then established. But ultimately, some of the issues that we raise are common cause on the pleadings. And on the issues that are common cause on the pleadings, we do not need primary evidence. Let me just go through those issues that are common cause.
At what stage, Mr. Mpofu, did you come up with this manipulative, systematic manipulation? When did you find it out?
Before the application was filed, you notice, my lord, that the founding affidavit
Right.
deals
That
with that
was
issue.
before the. You're saying that was before the application was filed, and that would have been within the 7 days, isn't it?
It wasn't.
Sorry.
So that would have been within the 7
The
days.
7 days required by the Constitution, within which the applicant, the aggrieved candidate, should take measures to challenge the validity of a presidential election. You would have discovered the manipulations that you are talking about during that same period, isn't it?
Well, it follows, my lord.
Sorry?
It follows.
Yes, it does follow. I am following you, I agree with you. It follows.
It does.
If it followed, what stopped you from doing what we are asking you should have been done?
Lord,
Why go for speculative conclusions of manipulation when you had those? You had the law on your side. You had, the applicant had the law, protective provision of the law, which says you have a right to even extend that time of 7 days or 5 days. If a court had said, look, he wants to open these ballot boxes, our law allows an application to be made to the electoral court to make an order for an extension of that, so that that process is cleared. And why did that not happen?
Lord, we're dealing with different things here.
Sorry?
The 5 days relates to something different. The opening of the residue is 2 days. Now, it's 2 days from the declaration. What happened?
48 hours.
That is correct.
Yeah.
So outside the 48 hours,
Yeah.
you cannot extend the statute. But the applicant's case must be considered in its context. 2 days after the declaration is when applicant...
You knew that law, isn't it?
Indeed, my lord.
Sorry? Yes.
Indeed,
The applicant knew about the law. He's a lawyer.
Without a doubt.
You knew about the law.
And I also did, my
The
lord.
applicant, yes, we appreciate that. So let's take it then, it was deliberate not to follow that section.
My lord, we cannot be put in a corner by the respondents.
No, it's not the respondent, it's the court. We are just, you see, don't take it like the court is putting in a way. The court wants to know the facts. and so that when it now makes decisions, it's not speculating.
That is correct, my lord.
You knew there was a 48-hour right within which to seek to open those documents, which would have been very fundamental to the case, even before you start, to decisions as to what to do next, what to challenge, what allegations to make against people. Those would have been very important. Now, you didn't do it, and you are saying you knew of the law, you knew the content of that right, and we want to know why you made that decision.
Thank you, my lord. My lord, I'll take this position again. Number one, the fulcrum of our case has nothing to do with election residue. It stands without the election residue, and let me just demonstrate that. Number one, the concession.
I understand your position now. Is that it had nothing, your position is that the outcome of your case, as you pleaded it, has nothing to do with the residues?
I've said the fulcrum.
Sorry?
The fulcrum, the pith.
Yes.
Yes, let me establish that
Yeah.
by reference to the numbers. Number one, the concession by ZEC at page 19 in bundle 4, which yields 8,944, has nothing to do with primary material. We take that. Number two, the difference in the parliamentary and presidential figures also has nothing to do with the residue. We take that, that's 40,000. We're now at 57,000. Number three, the ghost polling stations.
Sorry, if I could just take you back a little. The difference in the parliamentary and presidential votes. Your case is that this had an impact in terms of figures.
Correct.
On the results that was attributed to Mr. Chamisa.
Correct, my lady. Correct. But those figures have nothing to do with the residue. We do not establish or de-establish them from looking at the residue. So that was the second set of figures. The third, the ghost polling stations, which are not disputed, 9,592. Nothing to do with the residue. Fortunately, they took away my phone. I wanted to just do a quick calculation, but it is, let me just do a quick calculation. It's around 69,000 votes, which have nothing to do with the residue.
When you say ghost polling stations, what do you mean exactly?
That's the Magunje matter, where results were coming in, and suddenly tallies came from those two stations. Maybe let me take the quote to that. It's page 164 to 165 of the first volume. The document starts at page 164. Volume 1. Rows 11 and 12. 1 HRDC, 4 HRDC. If we turn over leaf, we see that ED is 3,334 on one of those, the second one 2,065. It is not disputed that the polling stations.
Just hold on, Mr. Mpofu, just clarify here. You said page 164.
And to 165.
Volume
1.
Volume 1. Page 164.
That is correct.
That is what is Annexure M.
That is correct. That is correct, my lord.
All right.
The 11th and the 12th.
All right. Yes.
So those results, 5,000 and that, it's 5,592, came from non-existent polling stations. And there is no dispute of fact on the core of that issue. So we're sitting at around 69,000 votes, which do not require the opening of the residue. Now, which ones require the opening of residue? With it in that manner. The first is the Marsh Central increase from 105,000 at 5:30 to 444,000. Do we open residue for that? I want to refer the court to the judgment in Mnangagwa.
Sorry, I just like to, I'd like to, or I want to follow what you are saying. The votes in relation to Marsh West or Marsh Central,
correct.
You are saying would require the
On the argument,
unsealing of the.
on the argument or on the question?
It's not on your.
No, not on our case.
Very well.
What I want to do is to establish why, even on that argument, there would be no need for us to go to Marsh Central and say open the residue. I've drawn attention to Mnangagwa, Matambo versus Mnangagwa. 1996, Volume 1, Zimbabwe Law Reports 101 SC at page 103. However charmingly, smoothly, or impressively Mr. Mnangagwa made these statements, the fact is that they are mechanically impossible. If a witness says he saw water flowing uphill, unaided by a pump, you do not judge his veracity by reference to his demeanor. You apply the law of physics. The Constitutional Court faced with ZEC, which says at 5:30, 105,000 people had voted in Mashonaland Central, cannot, with respect and on the application of this principle, accept when ZEC comes and says an hour and 30 minutes later, 444,000 people had voted. So even on that argument, there would be no need to open the residue for Marsh Central. Let us go to Midlands. ZEC, through its own chairperson, at 6 p.m., 1800 hours, says there's been a 60% voter turnout. In the figures that it produces, there is an 84.16% voter turnout on the Mnangagwa principle. This court sitting to consider whether the first respondent was voted into office by the people of Zimbabwe cannot, with respect, ignore this clear impropriety. So what do we have at the end? We have a false ZEC. We have a lying ZEC. False us in UNO, false us in omnibus. The Constitution requires that ZEC be transparent. The Constitution requires that ZEC follows a process that's verifiable. Can the court verify these figures on ZECs, on figures? Can it verify these figures? And if it cannot, with respect, significant doubt is cast on those figures. So even these figures on which that kind of argument could have stuck only produce one outcome.
But Mr. Mpofu, are these provincial results being received in real time, or they are results which are transmitted to a central point.
The actual-
and then announced.
Thank you.
And what prevents a situation where you say, I have received results which show this, while outside the truckload of the other impending results is waiting for you to receive and analyze?
Thank you, my Lord. My Lord, that is an issue of fact. When we place before the court evidence which shows that ZEC gave figures, it is up to ZEC to then say, because of A, B, C, D, and E, this increase was attainable within the hour. ZEC has not done that. But what does ZEC try to do? It seeks to hide behind a finger. It does not address the concerns raised head on. It seeks to drag the applicant into a recount or opening of the election residue. The applicant, for reasons that he has placed before the court, is not prepared to do so. But then ultimately the applicant is not obliged to go for the opening of the residue. Once applicant has these figures that is placed before the court, which are not disputed, that is the end. The rule of law is clear. What is not disputed in affidavits is taken to be admitted. And if you want to dispute something set out in the affidavits, you must raise a genuine and bona fide dispute. And if you do not do so, bold and bare denials will not make the allegations go away. So ZEC needed to have explained even these ones away. But as I've indicated, on the figures that are purely arithmetic, we have 69,000 under circumstances where we require 31,000 to establish that first respondent did not win this election.
Your responses, Mr. Mpofu, are you conceding that the primary evidence does not support the applicant's claim?
I'm not, my Lord. I'm not conceding that for once. I have said the primary evidence that we have divided into two. The figures that have been admitted by ZEC, the figures that are objectively established, show a plus 69,000 number, and those sustain applicant's case. I have then looked at figures which require me to argue a matter and show the court that this is possible, this is impossible, like Mashonal and Central and Mashingo. I have established that ZEC has not placed before the court a bona fide dispute, particularly given that the announcements on which we rely are ZEC's own announcements. Let me just take his lordship back. As regards Mashonal and Central, in its affidavit, ZEC says, this is from an online report. You cannot rely on an online report. That is what it says. What it forgets and what it does not address is that the online report identifies its official who is responsible for that province and ascribes to figures that she gave at a particular time. Now what ZEC is supposed to do is to place before the court evidence which shows that either the official did not give that interview, the official did not give those figures. B, ZEC can place evidence before the court which shows that when the official did so, she was mistaken. ZEC does neither. And there can only be one conclusion, and one conclusion alone. We are not fools. This is a court of law. When ZEC comes before this court, it must say something that makes sense. How does a court on ZEC's failure, or how does ZEC expect a court under these circumstances to believe that 370,000 people voted in 1 hour?
Does the primary evidence not constitute the best evidence available?
For the purposes of the three figures that take us to 69,000, there is no need for primary evidence. It is not the best evidence available. For purposes of Mashonal and Central and Midlands, the story on the figures is itself sufficient. ZEC has not placed a bona fide dispute of fact. My Lord, if ZEC had said, here is the affidavit of Mnangagwa, it is not true that I gave that interview.
Where does the onus lie?
Lord, in a matter, the onus changes depending on a case that has been made by one of the parties. If an applicant manages to show, for instance, that this national and central thing is unworkable, and ZEC fails to provide a proper answer, that is the end. At that stage, the onus is on ZEC to place evidence which would not make it lose. Let me put this differently. Onus lies on a party which would lose in the event of that onus not being discharged. If an applicant places before the court credible evidence identifying names and figures, unless those are disputed, the onus then shifts to a party which would lose in the event of it not establishing by evidence what is required for the purpose of a judgment of the court. And that is the kind of issue that we have. So I notice we have dealt with this from many angles. Let me close it again.
Just so that we are clear and together with you, you made reference to 60,000 teachers, of whom only 20 voted. What are you saying about the 40,000 in relation to actual votes?
Thank you.
That you are saying would have gone to Mr. Chamisa, or unless you are not saying that.
I'm not necessarily saying they would have gone to Mr. Chamisa. What I'm saying is that if the law imposes an obligation on ZEC to ensure that the 40,000 vote, and ZEC does not comply with that obligation, that's an irregularity. Now, in the context of this matter, in which 31,000 changes everything, once that figure is at 40,000, that figure is material in a manner which affects the outcome of an election. So once that is established, with respect, there is something that could potentially affect the outcome of the election. So if the law is accepted, and I submit the law on the subject is clear, there was a court order and there's section 92. If it is established, the law is established as it is, a material, one way or the other. Now, on the test in section 177 of the Electoral Act, that comes into play and would justify the relief that is at this point. The right to vote belongs to Zimbabweans by constitutional command. That right cannot be taken away, least of all by the state. A state which comes up with arrangements which ensure that its own citizens do not vote violates a fundamental tenet of the Constitution. When a fundamental tenet of the Constitution is thus violated, there is an irregularity which pertains to an election and which affects its validity. In fact, I'm prepared to go as far as demonstrating that by law, if an employer does not allow their employees to vote, that's a criminal offense. If the state commits a criminal offense which disenfranchises 40,000 people, how is an election of that nature saved by this court?
The state or it's ZEC. ZEC is a constitutional court, it's not a state. It can be sued in its own right for any violations that it has done or is alleged to have done.
Lord, at the end of the day, doesn't change anything really. ZEC is a body established by the Constitution. It is established to run elections. ZEC has come up with a program which ensures that there is no election for 40,000 people. How can that possibly be saved?
Provision for criminal charges, where a party or where an employer prohibits employees from voting. And I'm saying that those provisions can be activated with respect to ZEC. ZEC can answer for itself in that manner.
I have no difficulties
In
with that.
fact, a broader question is, what exactly did the first respondent do by themselves or by their agents which violated the law? It's not said in the papers.
On which aspect, my
It is
lord?
on what ZEC has done, ZEC has failed to do. But what has the first respondent done by themselves or through their agents, which should nullify the election?
In fact, my lord, that's an important issue. If I were to get a theme for my submissions, the theme would be ZEC has thrown first respondent under the bus. Does not matter who has thrown you under the bus will run you over. What ZEC has done is to violate the Constitution, to violate the Electoral Act in a manner which has ultimately benefited the first respondent. So it doesn't matter that the first respondent might not have been involved in the violations. I do not accept that he wasn't. But the point that I make at this stage is that it doesn't matter. But at the end of the day, there's another legal principle which is important. Qui facit per alium, facit per se. If you do your act through the hand of another, you've done it yourself. The Telesol judgment that we cite in our aids of argument says if something is done for your benefit, it does not matter that you are not involved in crafting that thing. But if something is done for your benefit and its invalidity is established, it affects you. So, my lord, ultimately, yes, we have this ZEC problem.
Perhaps, yes, that's a too broad legal principle. Which law can support that kind of proposition? I'm certain the law doesn't say that.
Which one in particular, my lord?
It does imply that the party concerned should also have been an accomplice of some sort, should have been a participant, or should have condoned some of the acts. We appreciate you are saying that you don't actually accuse the first respondent.
No, I'm not saying that. I'm not saying that, my lord. I'm not saying that.
You are saying what?
I accuse him. He is accused by the applicant. He's accused on
Yes,
the papers.
I mean the applicant.
But I'm simply saying I do not need to accuse him in order to have the declaration set aside.
The question was valid, I think, was that what we have been listening to, hearing is about ZEC doing this, ZEC doing that, ZEC doing that and that. But the court has not heard any allegations of malpractice. We know what malpractice is in terms of the law, the electoral law, in which the first respondent participated or is alleged to have done anything, either through his supporters or himself and so on, or through agents. And you did, I understood you as saying that you agree, you are not making those allegations.
I am, my lord, let me clarify.
All right.
I make all allegations against the first respondent. But let me deal with that intervention from two angles. Firstly, if it is established that ZEC ran a sham, if it is established that ZEC announced the wrong results, and ZEC concedes that it announced the wrong results.
What we are saying, we accept there's been a lot about ZEC conduct in the conducting of the election. Those are valid points which can be taken, they have been taken, the court will consider them. There's no problem with that. You still have the question whether in that context there's been any allegations of direct involvement by the first respondent in malpractices, either personally or by some form of proxy through agents.
Like raping people and sodomizing.
That is
some of
what
them.
the question was, and I thought perhaps you needed to just clarify that.
Indeed, my lord, and I want to answer that from two angles. Number one, it does not matter what the first respondent has done or not done. If it is established that ZEC did not run a proper election, he cannot benefit out of something that is unconstitutional. So, for instance, the court cannot say, we agree that ZEC is wrong, we agree that ZEC did this, but it is not the first respondent. Doesn't matter. That does not save the election. That's the first response. The second response is that the idea of electoral malpractices vitiating an election is a petition's idea. This is an Electoral Act standard which relates to electoral petitions. It is actually an additional ground for invalidating an election. Section 93, in his lordship's words, in Tsvangirai versus Mugabe, is a self-contained code. It does not require that you establish a malpractice before an election can be invalidated. Doesn't require that. The applicant has been very clear in this matter, and the respondents have connived to misunderstanding. He is clear in stating that the main basis of his challenge are the figures which do not add up, figures which ZEC has revised 3 times over, figures which ZEC still continues to revise, figures which ZEC places before the court without any verification. That is the main basis of his challenge. But to say, and I want to put this beyond any doubt, to say the applicant does not accuse first respondent is not, with respect, the correct position. The correct position is that applicant accuses both the first respondent and ZEC. They have connived to not only undermine his just interests, but they have connived to undermine the Constitution and the foundational basis of our participatory democracy. What's the...
Are you still going on?
I'm still going on. What the first respondent has done in his own right is separately articulated. For instance, he goes about giving people freebies, and he says this is a presidential input scheme in July towards an election. That is dealt with. The many other violations are dealt with. But because the applicant's challenge is mainly based on the figures, those figures are a ZEC product. But what is clear is that in all the irregularities, be they mathematical or otherwise, they have been meant to benefit the first respondent. You will notice that first respondent has never had any complaints against ZEC. Even when ZEC says to him, you cannot take these ballots and distribute them, he takes them and he distributes them, and ZEC says nothing about it. Not once does the first respondent raise any issues against ZEC. All the issues are raised by the applicant, and all the mistakes, the errors are meant to benefit and in effect, at the end of the day, benefit the first respondent. And that abdication by ZEC of its constitutional function cannot, with respect, and I submit that the court cannot allow ZEC to go scot-free on this kind of issue. So, my lords, my ladies, if we're to say today, the first respondent is the elected president of Zimbabwe, how many votes did he garner? And how is an election in which that question cannot be answered supposed to be saved?
I think we go back to the court application itself. I think your submission is that, or perhaps let me ask you this question. The rules require that process initiating or initiating process is served by the sheriff. You accept that?
I do, my lord.
And you accept that in this particular case, this was only done on the 8th day
By the sheriff.
by the sheriff.
I accept that the sheriff received an instruction to not effect service when he had 8 hours to effect service.
No, that's not the question. The reality is that the sheriff only served the application on the 8th day.
That is correct.
You accept that?
That is correct.
And what you're saying is that once the application is lodged on the 7th day, it matters not that service is effected on the 8th day.
Thank you, my lord. Let me take that again. In terms of Section 93 of the Constitution, whose effect cannot be attenuated by subsidiary legislation, what is required is to lodge the application. What gives the court its jurisdiction is the act of lodging. Lord, let me take this from an ultra jurisprudential perspective. The jurisdiction of the court is not established by the rules.
Sorry, is not established by?
The jurisdiction of the court is not established by the rules. The jurisdiction of the court is established by the Constitution. What the rules do is to facilitate the exercise by the court of its jurisdiction. Put differently, in constitutionally, that reality cannot be changed by consideration of the rules. The purpose of the rules is to ensure that once the jurisdiction of the court is entrenched, the exercise thereof is facilitated. The juridical impurity in the argument advanced by the respondents is that it collects the question of the establishment of the jurisdiction of the court on the one hand and that of its exercise. It makes that one thing. Cannot be, my lord, with respect. So once the jurisdiction of the court was assumed by the fact of lodging, that is the end of the matter. But let us be charitable.
Advocate Mpofu, I don't want to cut short on your eloquence, but are you suggesting that we ignore the rules in their entirety?
No, not at all, my lord.
If we are not to ignore the rules, surely the next step is for us, either on our own motion or on request by the applicants, to condone a departure from the rules. Isn't that the preferable way to go?
Thank you, my lord. Maybe let me make 2 points in that regard. If we fuse in the rules purposes of the exercise of the jurisdiction, we have to fuse in considerations of Rule 3, Sub-Rule 2 at the same time. And there can only be one conclusion. But secondly, my lord, if it is to be accepted that the applicant lodged his papers was charged by the sheriff, because the sheriff calculates how much it is that he wants and charges, was charged by the sheriff and paid, then that's in the remote
Advocate
event.
Mpofu, you're going off on a tangent again. The question is simple. Whatever might have happened in terms of the sheriff's failure to act or his deliberate reneging on an undertaking to act, the question is, what do we do with the rules?
Thank you.
They've been. What do we do with that breach? Do we ignore it or do we condone it?
Thank you, my lord. If the court were to come to the conclusion that there's been a breach of the rules, then I would move condonation on the basis that the applicant really had was not involved for this, was not responsible rather for this. He did everything that she was required by law to do. And my lord, as the court considers that there's this aspect, the applicant, in order to show that service was doable, effected his own service on the day. And the courts hold, in my respectful submission, in relating to the motion for condonation, which for the avoidance of doubt I make in the alternative, would consider, my lord, that the sheriff was supposed to cross Samora Machel to effect service at Munudaba.
Mr. Mpofu, are you making the application now?
I make it in the alternative. I make it in the event.
But you are making the application now?
I do on the basis of all the considerations that I've raised. But I'm clear, my lady, I make it in the alternative. And maybe in sealing that application, let me just make this point. It would be a sad day for our democracy if an applicant who challenges the declaration of an on ground a sheriff did not to do. The time available to the sheriff in this matter afforded him the opportunity to drive to Bulawayo, effect service and come back. Still on the 10th. He chose not to do so because he had been instructed.
And
For purposes of
come back and have a good night's sleep.
Indeed, my lord.
Yeah, on a different note.
And they have proper dreams.
On your heads of argument, you look at section 177.
Correct, my lord.
Are you aware of the case of Tsvangirai and another, 2005, volume 2, ZLR 398? And the Supreme Court version of 2006, volume 1, ZLR 148. These are the cases which in the popular media are regarded as never having been released or missing or embargoed or somehow held back in some kind of, one could call some outlandish conspiracy theory. You're aware of those cases?
I am aware, my lord. I am aware of those. I'm also aware of the theories.
Sorry, you're aware of the
I'm aware of the theories, and I'm also aware of how wrong they are.
I don't think the popular media is to blame. I think the legal advisors are to blame.
They are legal
Because
advisors for the
sometimes
applicant.
they forget that they are officers of the court, first and foremost.
Lord, you mean the legal advisors for the applicant?
And I bet, well, the legal advisors in general.
I see.
Not yourself.
I see.
Are you their legal advisors?
I'm not, my lord.
Now, those cases were handed down. And I noticed that in your heads of argument, if you look at Tsvangirai and Mugabe and another, the 2005 case, you'll find that it dealt with the issue of the interpretation of section 177. And went into a historical background to that particular provision, you will notice that the original provision by the Act of Parliament contained the disjunctive or. It was only the law reviser who then came up with the conjunctive and. And that case made the decision that the proper position is that the two paragraphs are separated by the disjunctive or. And you could have made that point in one paragraph and not in 10 pages and several paragraphs.
Quite right, my Lord.
Sorry?
I accept that, my Lord.
Yes.
I accept that.
Yes.
I
Or unless you also thought that judgment was missing.
Lord,
Yes.
well, just to indicate on that issue, that I had 2 days to do 2 massive answering affidavits and heads of arguments. So a couple of things could have been missed here and there. But His Lordship is quite correct. That is indeed the correct legal position. And my Lord, it is supported by a welter of regional authorities on the subject. There's particularly an interesting Indian case on the matter as well. But because of the time constraints, we're not able to place it before the
You
court.
did the hopping around through Kenya, the United Kingdom, and India, but charity begins at home.
It does,
Yes.
my Lord, it does, my Lord. And if charity had begun at home, some sleepless nights could have been saved. I accept my Lord.
May I thank you, Mr. Pofu, for having taken us through this very well argued. We do appreciate your assistance. We do also appreciate you did quite a lot of work in 2 days and failed to sleep. We do appreciate that much. We have therefore hopefully come to the end, because this was a portion under the control of the court. You can see it was the judges asking questions. It's entirely under our control, and we are closing it now. And we will now open the doors to the respondents when we come back after lunch. We will take a break of 40 minutes. That will, according to our calculation, will take us to about 3:15, and we'll resume the proceedings.
Please, not just that I didn't want to be pitted. I would have indicated that the founding affidavit was completed at the avenues where 2 of my children were admitted. It was for a worthy cause.
We do appreciate. We don't know what effect those sympathies will have.
That's why I said I didn't want to be pitted. It comes on the backdrop of His Lordship having indicated the work that we did in 2 days in terms of the answering and the heads.
Anyway, thank you. The court will adjourn.
ichokwadi maya ndozvikuitika kuno kuConstitutional Court. Taona advocate Tabani Mpofu naadvocate Ashiti vari kumirira vakakwidza nyaya yekubata redzimhosva vaNational Chamisa vachitaura umboo hwavainahwo vachitsanangura sei kuti vakakwidza nyaya vachibvunzurudzwa nemagweta